Good morning, everyone. Welcome to the Revenue Committee. We're going to go ahead and get started here. The roads aren't the best, and Chairman Harshman's running a little behind, but we've got a good senator and a good representative here to present some bills to us, so we'll go ahead and get started. Would you like to call the roll?
Yes, good morning. Representative Baer.
Here.
Representative Byron.
Here.
Representative Locke.
Present.
Representative Northrup.
Here.
Representative Oakley.
Here.
Representative Storer.
Excused?
Representative Strzok.
Here.
Representative Swanitzer.
Here.
Chairman Harshman.
Excused.
Thank you.
Thank you. Okay, so the first Senate file that we're going to discuss this morning is one that came to us via, there's actually an ICWA task force, and we've got two members of that in front of us today. So Senate File 18 and Vice Chair Larson and Senator Ellis, if you'd like to go ahead and walk us through the bill.
Thank you, Madam Chairman and members of the committee. Over the course of this last year, the ICWA Task Force convened, and as you will recall, last year we took basically the language of the Federal Indian Child Welfare Act and put it into state statute. And then in anticipation of Supreme Court case, the Brackeen case, where there was the potential that the Indian Child Welfare Act might be vacated, and then states would have to rely upon their own statutes to administer what they have historically done for Indian children who are under protective orders or adoption. And so we adopted, the good Vice Chairman of Tribal Relations had a bill last year that we adopted that put the federal law into state statutes. And in doing so, we created the task force that then would look to see if there's any further adjustments that we needed to make in our state statutes. We met several times. We have Councilwoman Returns Tour, I think, that will be testifying today. We had her and members of the Eastern Shoshone Tribe, as well as members of the judicial branch and state agencies. The Department of Family Services serve on that task force to see if there's any areas that we needed to remedy in our state statutes. One of the areas that that was brought to our attention was the safe haven laws, where a mother with a newborn child currently under the age of 60 days can turn that child into a safe haven that could be at a hospital, a fire station. They've got them designated in statutes, and then there will be no penalty or action against that parent as that child is then put up for adoption. If there's a period of time there that the parents can come back and say, no, that's a mistake, we've got things figured out in our life, or if not, then the Department of Family Services, who at that point has guardianship, legal custody of the child, would start adoption proceedings and working to that end. The Safe Haven Law was created decades after the Indian Child Welfare Act was created in the 70s, and the Safe Haven Act doesn't contemplate in there the provisions of ICWA. And you'll recall the provisions of ICWA really are that if there's an Indian child that is eligible for adoption, that the child's and the parents aren't involved, that the child's tribe has the right to intervene and participate in those adoption services. And so what we did then is, upon recommendation of the courts and the tribal members involved in the ICWA task force, is we went into the Safe Haven statutes in 1411 and we amend them to, and what we do is And there was kind of a balance there that we had to do, because when a parent takes a child in a safe haven setting, there's not a lot of questions. They don't get into a lot of the details. It's kind of kept at arm's length and give them, but yet at the same time, to the point of how ICWA applies, there needs to be some questioning to determine if the child is of Native American ancestry. And so what we do is we go in on page, if you look at page 2, we add the new language and we say that the safe haven provider must, we use the term shall, ask the parent or the parent's designee whether the child has any tribal affiliation or Native American ancestry, and request relevant information to determine the child's tribe. Then the backside of that is we say the safe haven provider shall not require that any information be given or person relinquish, express an intent for return of the child. And so we make sure that the questions asked, but then we try to maintain the balance that we don't force the safe haven provider to require that information be given. And then down in 105, we note and make reference in this safe haven law back to 14.6.702, which is the statutes for our state ICWA law that was put into place. And if the child is of Indian child, as defined by that statute, the court and all parties shall comply with the Indian Child Welfare Act. So, Mr. Chairman, that is how we bring the ICWA provision into the safe haven law in our statutes, and would be happy to answer any questions.
Thank you, Vice Chairman Larson. Senator Ellis?
Thank you, Madam Chair. I think the only thing I'd add is when you look at the fact patterns of how these ICWA cases are usually challenged, it's because the state isn't reaching out to tribes early on. There are certainly instances where you could reach out to a child's tribe and they are aware of the child, the circumstance, and they opt not to intervene. They don't want to participate. And they're like, okay, we were notified. Thank you for satisfying ICWA. But the problem that you see is when ICWA is not being followed and then the tribe becomes aware, years after the fact, and the child's placed in a family, they start developing bonds, and that's where the conflict arises, truly. And so the earlier we are able to identify a child's tribe, if applicable, the better it is for everyone involved. So this, in practicality, I think the person relinquishing the child would say, I don't know, or yes, or no. So I don't think this is an important or a huge burden on the safe haven provider, but I think it helps us comply with law, which is in the best interest of kids and families all around. So it's a good little bill.
Thank you, I guess Chairman Ellis. So questions from the committee? All right. Oh, go ahead, Representative Bear.
Thank you, Madam Vice Chair. And either of you can answer this question, but if there's a requirement for these questions to be asked, this inquiry, can it cause delays in getting the child to a safe haven, or if you're in a crisis situation, is there any concerns with that?
Madam Chairman, Representative Baird.
Go ahead, Chairman.
It's at the safe haven facility where this question takes place. So I would, I guess, answer that in saying no, because it's within the confines of the safe haven where that process takes place.
Follow-up, Representative Bear.
Thank you, Madam Vice Chair. You had mentioned, I believe in your testimony, that the safe haven laws came about after the ICWA Act of 1970. Is there any particular reason that you can think of that these provisions were left out at that time?
I'm sorry, go ahead.
Thank you, Madam Chairman, Representative Bear. We kind of had that same conversation when we was having our task force meetings. It was brought up by the agency, Department of Workforce Services, that it was not in there. Don't know the congressional conversation that went on with the safe haven laws, but clearly absent.
Go ahead, Representative Bear.
Thank you. One last question, Madam Vice Chair. We have another bill going through, I think, the other direction that talks about safe havens, and it's sort of a device where you wouldn't be able to ask questions. And I could foresee there being a situation where you never have a chance to ask if a child is from a particular tribe. Is there anything that can be done about a situation like that? Or are there DNA tests, that type of thing, as part of this process?
Go ahead, Vice Chair Larson.
Madam Chairman, and I will also divert to Chairman Ellison and perhaps Ms. Schilling from Department of Family Services. But I think what the intent is in the safe haven law is to provide a safe environment that those who are bringing the child don't feel imposed upon or judged, and so I think the intent of safe haven has always been to keep some privacy and to not delve into the personal understanding of why the child is maybe being brought to the safe haven. And so what is the least intrusive way of doing that? Is it through asking a question of which they can or are not compelled to respond, or is it then getting a DNA, which I think some would argue might even be more intrusive, to get a DNA sample from the child? To then that I think potentially raises a number of questions on tribe and whose child and parental, so I think the intent of safe haven and the intent of this work was to try to thread the needle between the intent of safe haven and the intent of ICWA, to where the child, if it's known that is of Native American blood, their tribes could be then notified for participation, and yet not get into the rationale or the decisions of the parent at that time.
Go ahead, Representative Bear.
Thank you, Madam Vice Chair, and I had said that would be my last, but I apologize. This kind of brings up another question that really probably goes more back to ICWA, but which is the priority when we're asking these questions, and what are we trying to get to? Is the priority complying with ICWA, or is it the best interests of the child?
Vice Chairman Larson, go ahead.
Madam Chairman, I think that the basis of ICWA has always been that ICWA is in the best interest of the child.
Thank you. Further questions for the good chairman? Thank you both. Go ahead.
Madam Chair, if I could just kind of back up to, this part deals with the questions that are asked when the person relinquishing the child presents the child. And you'll see, if it's the non-parent, they'll say, well, do you know who the parents are? That's a question. The other one is, do you have any medical history information? Because if the child has certain medical things, we want to know that fast. So I think these questions are all geared toward doing what's right for the kid, trying to not impose too much, as my good chairman mentioned, on the parent and the circumstances that led them to need to relinquish the child. So I don't think it's overly burdensome to ask, if it's the parent, they would say, well, do you know of any medical issues? Do you know if this child has Native American ancestry? That's it. So I just want to put it back to the real world. I don't think this is a huge imposition. And on the back end, as I mentioned, the purposes of ICWA and what's in the best interest of the child are aligned. Keeping children aligned with their families is always in the best interest. So this aids in that. So I don't think they're separate questions. I think they're both are satisfied.
Thank you, Chairwoman. Further questions? Okay, thank you. Do you, Representative Swanitzer, go ahead.
Thanks, Madam Chairman. It just concerns me, what if they don't ask, right? It's, they get dropped off to a fire station and you find out years later. Is there like a course of civil cause of action then, that when this child was dropped off, it said you shall ask and you didn't? What's the consequence or penalty, I guess is my question.
Chairman, either one?
Madam Chair, I think what you'll see is if a child is placed in a non-Indian home and the child's tribe eventually finds out about it, the underlying cause of action will be ICWA compliance. I think that gets wrapped up into that argument or that proceeding. I don't think it imposes additional liability.
Thank you. Thank you both. Appreciate it. Yeah, so I see two. I see a state agency. There we go. Good morning. Go ahead and introduce yourself and proceed with your testimony.
Good morning, Chairman, Co-Chairman. My name is Lindsay Schilling. I'm the Senior Administrator for the Department of Family Services. We had an opportunity to work really closely with the task force throughout the course of their work. This bill really does just carry the spirit of ICWA into another section of Title 14, provides us some more guidance in statute in how to handle these types of cases, and really, I think, gives us an opportunity to keep tribal infants with tribes whenever possible when the information is provided. So I'm here to answer questions if anybody has any.
Committee, questions for Ms. Schilling? Great, thank you. Thank you for working, for being here. Governor's Office and Tribal Liaisons, go ahead and come on up. Good morning. Go ahead and introduce yourselves, and as soon as you're done being harassed.
I know, it's, Madam
Go ahead.
Chair, it's a rough crowd. My name's Kit Wentland, Special Counsel, Tribal Relations Policy Advisor for Governor Gordon, and we'll have our liaisons introduce themselves as well.
Good morning. Good morning, Chairman, Chairwoman. I'm James Sarles. I'm the Tribal Liaison to the Eastern Shoshone Tribe.
Go ahead, Ms. Roman.
Good morning, Chairman and Committee. My name's Anita Roman. I'm the Tribal Liaison for the Northern Arapaho Tribe under Governor Mark Gordon.
Well, welcome, and go ahead, Mr. Wentland.
Thank you, Madam Chair. I'll give a quick little spiel here, and then I'll turn it over to James and then Anita. The Governor's Office supports the good work done by the task force here. There was a lot of heavy lifting done in the interim, and of course supports being able to make sure that Indian children on the front end, you can determine this earlier so that they're placed in compliance with ICWA. So just speaking that Governor Gordon does support this act, and I'll turn it over to my two companions.
Great, thank you. Mr. Soros, go ahead.
Good morning, Chairwoman Lockley Committee. Yes, I do know that the Governor Gordon does support this. It is a good one for the children that do get placed in these safe havens because of whether one problem or the other. It's not a real thing that we would like to see. We'd like to see the children raised by their own parents, but if that doesn't happen, we would like them to be placed within another home, hopefully another family member or some tribal member that would care for them. Thank you.
Thank you. Ms. Roman, go ahead.
Chairwoman Oakley, sorry, got a little nervous there. I just wanted to clarify that Governor Gordon's office supports this, as well as I've got to witness the good works of the task force, and the Councilwoman Returns to War for the Northern Arapaho Tribe has vocalized, as well as their lawyer, and as well as the Eastern Shoshone Tribe. So there's been so much work and a lot of involvement between the state and the tribes.
Thank you, Ms. Roman. Questions for the tribal liaisons or the Governor's Office? Representative Bear.
Thank you, Madam Vice Chair. And for either of the tribal representatives here, and I appreciate your being here today, can you tell me, are you aware of safe haven drop places within the tribal territories that are out there? How many are they being used? Are you familiar with any kind of this issue coming up?
Mr. Soros or Ms. Roman?
Chairwoman, Representative Bear. So on the reservation, I do know that like DFS steps in the place, as well as the hospitals. So there are oftentimes those communications that are happening.
Mr. Soros?
Thank you, Representative Bear. Chairwoman Oakley. Yes, there is, the fire departments. As you mentioned, DFS, there's also DVS. And some of the early intervention, you got Head Starts. You have some some of these other places that do see this happening. Thank you.
Thank you. Committee, any further questions or comments at this point? Okay, thank you. Thank you all for being here. Anybody else in the room? I do believe we have a councilwoman online. Anybody else in the room? Mr. McNiven? No? Yeah, I believe she is. Is that accurate? Can we go ahead and bring in Councilwoman Returns to War, please? Good morning, Councilwoman. Can you hear me? We can't hear you if you are on. I think maybe we're getting you. There you go.
Ina dos hitati na kusage. Nanana na dil kusay. Can you hear me?
Yes, we can. Go ahead, Council.
Nanana na dil kusay. Ni think jana na da handon. I just said good morning. Good morning. My Arapaho name is Sitting Woman. I am glad to be here. It's good to see all of you again. I've seen each and every one of you at one point in time. I would also like to add that I have been a member of the task force. I just want to provide testimony, especially for, I know some of you were present when I had spoke at the last testimony. I am one person. I am a good example of why the ICWA deal is very important, and the amendment to the safe haven also. I was actually adopted by a maternal uncle, and we lived in Nebraska and lived in the Four Corners area in Farmington, New Mexico. I did return to my natural family when I was 7 years old. I can tell you that living out there amongst other people, other races, not my own people, was not enjoyable. My adopted family were light complected, and so I didn't really fit in there because, as you can tell, I'm got a darker complexion. You can definitely tell I'm Native American. And so I had to deal with all those issues. That's just one of them. I also did not know what it meant to be a Northern Arapaho woman. And for us, that's really extremely important. I mean, you go back to what America stands for. And as they say, and I was taught in high school, it was called America was called the melting pot for all races, ethnics, all people from different ethnic backgrounds. We all have roots somewhere, and our roots are here. Northern Arapahos, we wandered the plains. I'm extremely glad and grateful that I was able to come back to my people. My mother comes from a very traditional Northern Arapaho family, really instilled. I learned all that. My father, on the other hand, his father, my grandpa, he went to school at Carlisle. So on that side, education was extremely important to us. As we were grown up as kids, my parents come from the boarding school era, where it was wrong to speak our native language, our Northern Arapaho language. It's really important. Us as the Northern Arapaho people, Eastern Shoshone people, Indigenous people, our children are sacred. They are always sacred. I don't believe that, I don't believe that the intent, nobody knew when the boarding school area, the adoption here within the Wind River back in the 50s, 60s, well, the 60s and 70s, our social workers here at BIA really encouraged adoption. And so that left a lot of our people who were unable to have those roots in our communities, to be engulfed in our language, our ceremonial, our social activities, our way of life. Hinana'etit, our Arapaho way of life. I'm glad that I can speak some of my Arapaho language. I'm glad that I know where I come from. I'm glad that I know the history of my people. And this is what I want each and every one of you that are here today to understand. I know you can't fully understand what it is to be a Native American or a Northern Arapaho, but you can understand from your own history, your own family. Where do you come from? What are their traditions? I know you can understand each and every one of that. So with that, I just want to say thank you for your time and all the work that that's been done by the ICWA Task Force and all the committees, the House of Representatives, the Senate, Governor Gordon's office. Thank you.
Great. Thank you, Councilwoman Returns to War. We appreciate your testimony and all your work as well. Excuse me. Any questions for the Councilwoman? Great. Thank you. And you probably know, Councilwoman, but we'll be doing another ICWA bill next. Okay. So any further testimony as to Senate File 18, right? Yes, Senate File 18. All right. Thank you. I will close public comment.
Move the bill.
Bill has been moved by Chairman Harshman, seconded by Representative Zwanitzer. So any amendments? Any further comment?
Question.
Question having been called. Ms. Jeffrey, will you call the roll?
Representative Bear,
Aye.
Representative Byron,
Aye.
Representative Locke. Representative Northrup. Representative Oakley,
Aye.
Representative Storer,
Aye.
Representative Strock,
Aye.
Representative Zwanitzer, Chairman Harshman. The vote has passed with 9 ayes.
Great, thank you. All right. Committee, moving right along. We have, as we've mentioned, another ICWA bill here from both the ICWA Task Force and the Select Committee on Tribal Relations. This is Senate File 37, which is the delinquency amendments. And we have the good chairman here, if you will go ahead.
Thank you, Madam Chairman. Members of the committee, when the task force got together to review the ICWA statutes, one of the things that come to our attention is as we were bringing Child Protective Service statutes out of our existing law into our new state ICWA statutes and making reference and say that it'll comply with ICWA, with the ICWA statutes. One of those that we brought in was 14.6201, not 14.6, but the delinquency requirements, that if a child, a Native American child, was brought in under delinquency charges, then the courts had a responsibility to notify the child's tribe, and they could intervene and participate in the proceedings. What that, in Fremont County, where, in Hot Springs County, where we surround the Wind River Reservation, when you have a juvenile delinquent that is outside, if the juvenile has been charged with the delinquency act within the reservation, that goes to tribal court. If it's outside the reservation, they're brought into district court. And the way that works right now is for the most part, there's a hearing where the tribes and the DFS and local government meet, and they can refer that delinquency hearing back to tribal court, and is often the case, and they resolve it there, particularly if the child has residency on the reservation, if they live on the reservation. And so the intent, this kind of worked well for that. But as you get out away from the reservation, the rest of the state, let's say in Goshen County, there's a family living there and their tribal affiliation is in Oklahoma. And the requirement then for the district the court is to involve that Oklahoma tribe. It becomes problematic because we're in two different jurisdictions, two different states. And so we clean that up and bring it back to the jurisdiction within the state where the action took place. And so we remove that delinquency petition language on page 1 on line 14, and then and then we take out of Title 14 the reference back to ICWA. That's the repealer. And then on Section 3, the Senate made a very good amendment. We had the effective date being July 1. They changed that to effective immediately, which just made good sense. And so that's really what we're doing, is cleaning up that statute to make sure that it stays within the jurisdiction of the state of Wyoming. And then they'll work with for our tribal members, work with those two tribes on the reservation.
Great, thank you, Chairman Larson. Chairman Ellis?
Thank you, Madam Chair. And just to add on to that, when we codified ICWA, and Department of Family Services can testify to this a little bit better, Wyoming's an outlier in how we have handled these juvenile delinquencies and how they're looped into Title 14. And I'll let Department of Family Services explain that. So as my good co-chair mentioned, we have agreements with our tribes. A lot of that's contractual because we help them, or don't help them, but there are contracts in place for administration of certain family service programs. But where we do see confusion is when you contact tribes out of state. Juvenile delinquency is explicitly excluded from ICWA. So what they're experiencing is they'll contact someone out of state, a tribe out of state, and they'll say, why are you calling us? What are our rights? So can we actually have this case transferred out of state? And so it is confusing. In addition to hearing from the Department of Family Services, our Supreme Court has a juvenile justice project. I presented this bill and talked about the ICWA codification, and they raised this issue to me too. So this actually makes our law more consistent with the federal law and avoids confusion, and it leaves in place all those relationships that we have with our tribes internally within Wyoming. So would ask that you support the bill.
Thank you, Chairwoman Ellis. Questions for the good chairman? Great, thank you. DFS, would you like to come up? Good morning, Director. If you would introduce yourself and then proceed with testimony.
Good morning, Madam Co-Chairman. Corin Schmidt, Wyoming Department of Family Services, and it's nice to see this committee. I'm just here really to answer any questions because this is a little bit of an anomaly. As the good senator said, it kind of creates a lot of confusion once we start to interact with tribes out of state. So you could imagine on our eastern border where there may be some tribal back and forth between the state and the tribes located close to the border, up north in Sheridan where we have tribes in Montana. So this just really conforms all of it to what is typically experienced throughout the U.S.
Thank you, Director. Questions, comments? Okay, thank you for that, and I'm sure you'll stand by if there's any further questions. Go ahead, Governor's Office and Tribal Liaisons. Just for the record, if you would briefly again introduce yourself and proceed with testimony.
Chairwoman Oakley, again, my name is Kit Wentland, Special Counsel, Tribal Relations Policy Advisor for Governor Mark Gordon, and I'll turn it over to James and Anita.
Go ahead, Mr.
Chairman
Soros.
Oakley, committee, I'm James Sarles, tribal liaison to the Eastern Shoshone Tribe out of Governor Gordon's office.
And Ms. Roman?
Chairman Oakley, representatives, Anita Roman, tribal liaison for the Northern Arapaho Tribe.
Go ahead.
And Chairwoman Oakley, similar to the last bill, defer to the good work done by the committee, the ICWA task force on this bill as well. The practical need, the governor's office supports this bill, defers to that work, and the good work done by the tribes that were also involved.
Mr. Soros?
Chairwoman Oakley, yes, Senate File 57 in the Child Welfare Act, delinquency amendments. I believe it's a very good bill. I believe we should support it. I do hope you support it. The governor does support it as well. It is a good one. We'd hate for these children that, just, happen to be on the wrong side of the law once in a while. It happens to many, many people, but, like for them to be, not lost in the system, I guess, so to speak. All right, thank you.
Thank you, Mr. Soros. Ms. Roman?
Chairwoman Committee, I froze up there. I was like, okay, sorry. We defer to the good work of the committee as well. Governor Gordon's office does support this, and it was just really good to see the language get cleaned up and just kind of align with everything, so.
Great, thank you. Committee questions, Representative Bear.
Thank you, Madam Vice Chair. This is a question for the tribal representatives. How are proceedings handled within ICWA or at least the tribal courts for delinquency? And do you have any concerns with us determining that there is no requirement for the state under delinquency hearings for children to defer to ICWA? And we're repealing that statement where we have to defer to ICWA. And so we'll no longer need to do that. Do you have any concerns about that?
And who would like to take that? Mr. Whalen?
And Chairman Oakley and Representative Bear, I don't want to step on the liaison's toes. I do know that gets into some technical agency level matters, so I think DFS also could have some insight into how the proceedings under ICWA, when it gets into that stage, can be pretty technical. So I just want to make sure we get you the correct information, if that's all right.
Thank you. And any insight there, Chairman Larson?
So as we've tried to navigate what is appropriate relations between the state and the tribes over the last decade or so, we've relied a little bit, well, more than a little bit, on the Casey Foundation to see what other tribes and other states are doing, and feel really pleased at the direction that the state and the tribes have taken to this point. And a decade or so ago, what you saw was that the state agencies come in, so the tribes are sovereign, they each have their own respective Department of Family Services. The state help funds that. A decade or so ago, the state just run them. And they would come in and tell the tribes, this is what you have to do, this is what you're going to do, and kind of was the end. And we backed off from that at their suggestion, recognizing their sovereignty, and now we enter into contractual agreements that say that we acknowledge that they respectively have the responsibility for the supervision and the protective custody of their children. But they're also citizens of the state. And so they provide, under their tribal law and order code, they have governance over protective services for their children, but they also have some expectation that the state would support them in that effort, which we do through our appropriations. So in how the state then interacts with that is there's a negotiation with each tribe that Mr. Wentland and the Department of Family Service participates in, where they say this is the funding comes through us. We provide this funding at a request, and this funding is here, and here are some conditions that surround that funding. This is what we expect, and that's largely information. Tell us guardianships, tell us how many kids you have in foster care, tell us how that's going on. Then the unique thing is then there's a relationship where in Wyoming, in Fremont County and Hot Springs County, that the respective tribes also assist in child protective issues for those Native American families, tribal members who are living off the reservation, and they'll help investigate and mediate and provide guidance for those child protective services. Even though they took place off the reservation, they bring them back in, trying to comply in the truest sense, I would argue, with the intent of ICWA. So that's kind of how we do it here. Once you step outside those counties further, get further into the surrounding state, you'll see the compliance of ICWA in the more traditional sense that you would see across the United States. Is that fair, Lita?
Thank you, Chairman Larson. That's helpful. Any further questions or comments for the Governor's Office of the Tribal Liaisons? Great, thank you. Further testimony in the room, Ms. Butler?
Madam Vice Chair, Bill Winnie, Sublette County.
Mr. Winnie, go ahead.
Madam Vice Chair, Bill Winnie, Sublette County. 30 years active duty in the Navy. I'd simply like to note for the committee's information that Native Americans have always been strong, courageous members of our armed forces. I didn't see too many of them in the submarine world, but I saw them in other places, shore duty, and they're strong performers. To the extent these bills, both of these bills, support that, I commend them to your consideration, subject to your questions. Thank you.
Thank you, Mr. Winnie. Questions for Mr. Winnie? I just want to say I appreciate that. I've got a lot of, may not be relevant, but I'm going to take the privilege. Many Native American veterans and friends, and actually it's the highest percentage, Native Americans are the highest percentage of, as far as an ethnicity in the armed forces. So thank you for that. Ms. Butler. Good morning. If you'd introduce yourself and then proceed with testimony.
Good morning, Madam Chairwoman, members of the committee. My name is Elisa Butler, and I am the State Court Administrator for the Wyoming Judicial Branch. Madam Chairwoman, I don't really have much to add here except for to say that the Judicial Branch is fully in support of this bill. I think it clears up some substantial confusion that could be created by including delinquencies in the Wyoming ICWA law. And Madam Chairwoman, I'm happy to answer any questions if there are.
Thank you, Ms. Butler. Any sort of technical questions as far as this goes for Ms. Butler? All right, great. Thank you, committee. Are you coming up to testify, Mr. McNiven? Perfect. Good morning. Please introduce yourself and proceed with testimony.
Good morning, Chairwoman. My name is Travis McNiven here on behalf of the Northern Arapaho Business Council. Councilwoman Returns Toward just asked me to, again, express her appreciation and support of this bill as well, and that certainly appreciated Representative Bear's question along the lines of delinquency. As has been explained, this bill allows ICWA to conform as it is, cleans up that confusion as it relates to delinquency as that is outside of ICWA. So it certainly allows for the agencies and stuff, but still leaves in place the excellent working relationship that, as Representative Larson explained, with each tribe's individual Department of Family Services and the state, and the unique, and I would certainly say excellent communication that goes there. And so with that, would certainly take any questions.
Thank you, Mr. McNiven. Committee questions for Mr. McNiven? And so then just to confirm, the councilwoman doesn't want to testify, isn't going to testify in this bill?
That is, well, she asked me to, yes.
Okay.
Thank you.
Great, thank you, Mr. McNiven. Further testimony as to Senate File 37. Great, with that, I will close public comment. Committee, what's your pleasure?
Move the bill.
Bill has been moved by Representative Northrup, seconded by Chairman Harshman. So on the bill, any amendments, discussion? Question having been called, Ms. Jeffrey, will you call the roll?
Representative Bear.
Aye.
Representative Byron.
Aye.
Representative Locke. Representative Northrup. Representative Oakley.
Aye.
Representative Storer.
Aye.
Representative Strzok.
Aye.
Representative Swanitzer. Chairman Harshman. The bill is a due pass with 9 ayes. Thank you.
Okay, very
Thank you all.
good. The next bill for our consideration is Senate File 55, Board of Equalization, questions for the board. And we have a member of the board here today. This is a little friendly bill of ours that we had last year. I saw it passed Senate 32-0. And it's back again after failing in the House last year for some unknown reason. But anyway, here we are again. So go ahead, introduce yourself to the committee, and please take us through the bill.
Good morning, Mr. Chairman, Madam Co-Chairman, members of the committee. My name is Marty Hardsog. I'm Chairman of the Board of Equalization. And I can assure you that hanging on every word is my co-board members, Jane Mockler and Dave Delacath. It's my pleasure to see you all again with respect to this bill. I think it was last October we spoke last. I am going to approach this just kind of like I did in front of the Senate committee, and I just want to get out in front and of course, Chairman Harshman, you mentioned that it died last year, and that's in fact true. It died in the second house, either the second or last reading. And I wasn't there. I wasn't sure what happened. I heard that some folks all of a sudden thought there was something untoward going on. The board was possibly reaching or something different that they didn't quite understand or trust. And I can tell you right now, you can have full confidence that this bill is extremely simple and very straightforward. But I'm also going to explain to you why somebody might get that impression so that you are fully comfortable with what we are trying to do here. So the bill simply is clarifying that the board has the authority it's had from the beginning of its existence, 1869. The board has always acted as some kind of a court for tax disputes. And you might ask, well, why is this language even necessary? Why do we need to put this language in there if it's something the board always had? The ability to answer questions that or to raise questions that the parties didn't focus on. And the answer is this: we had a Supreme Court decision that came up. It was a mineral tax case, soda ash, and the parties came before the board. It was a deduction, very technical, and these tend to be the more complicated cases we get, mineral tax cases, especially valuation, natural gas, coal, oil. This one was soda ash. I've been dealing with mineral taxation for 25 years and change. And so I can tell you it's a little esoteric at times, but this was a tax case dealing with the bagging cost of soda ash, and the parties came before the board with a dispute about a deduction. And the board looked at it, and they were both assuming that there was a deduction, and yet the valuation statute had this thing called an industry factor. And when you read the statute as a whole, it doesn't appear that you get an additional deduction on top of this industry factor. This is going beyond what you probably need to know, but you'll understand the context. So we asked the parties, we said, look, we need you to address this additional issue. You didn't see it, but we sure do. And it's right at the heart of the statute you're talking about, but you are not interpreting the statute like we always have in the past. And so we brought them back in, had them do some briefing, had an additional argument. We didn't ambush the parties with a decision where they didn't get to speak to the question. But we did raise it before them so that they could answer, and speak to it and provide us their explanation and interpretation of the law. And so we had that, and then we had that all on the record, and then we addressed the issue and resolved it and determined that there was no deduction whatsoever. They already had a deduction. They didn't get an additional deduction as they were assuming. Well, the taxpayer didn't like that and said that procedurally we could not do that. And 3 members of the Wyoming Supreme Court agreed, and 2 in a dissent said, no, that's just fine. But what I want to point out to you is that every single court, and I'm not just talking about the judicial branch, if we're talking about workers' comp, if we're talking about the OAH, any kind of tribunal has to be able to look at the law in total. The parties don't always get it right. They don't always come to you with a well set forth breakout of the law, and the court, the tribunal, if there's a judicial function, has to be able to take the law, whether those are the rules, the case law, or the statutes, and say, look, here's what we're dealing with, and you folks, you 2 parties, 3 parties, haven't looked at this part of the law. That's in fact what we did in this case, and the court says, well, you can't do that when you're wearing your judicial hat, which I just, without too much more explanation, I just don't get, but that's what happened. So the language that we're talking about here simply says, we as a court, when we sit in an adjudicative function, can make sure we apply the full law. If the parties don't happen to get something right, then we can tell them we need to look at this part of the law. You have missed it. It's happened probably 4 or 5 times since the Solvay case. That's the case I'm talking about. And we've literally had to drop a footnote into that case and say, well, the parties did not cover this point, and now we can't. So we're going to have to answer which party is less wrong. And that's pretty awkward, because what happens then is we're issuing a decision we know isn't complete. We know that there's a problem with it, but we don't have authority according to this 3-2 decision at the Wyoming Supreme Court to get the parties to fully address their dispute. So if anybody comes to you and says, well, this is an overreach, or there's something that they shouldn't have this authority, you can be confident that they're wrong, or that they don't understand what we're doing here. We're simply required to get it right. And if the parties, for whatever reason, don't come to us with a full understanding of the law or a full articulation of the statutes, they haven't considered a part of it that they needed to, we have to be able to say, look, let's get everything on the table so that we can talk about it and make sure that we get the right answer, so that future parties aren't misled or assuming or relying on a decision that's incomplete. So the language that we're adding to is our functional jurisdictional authority. It's 39-11-102.1. And it simply says in the two sentences that the party is not limited to the legal interpretations presented, which simply means that if the parties, when they lock into an interpretation, if they both get it wrong, and we see something in the statutes or the rules or the case law that they haven't considered, and it does happen, especially with pro se litigants. But in this case, it was the Department of Revenue and the taxpayer, that we can have the parties address that so that we get the final answer correct, and that it's based on a complete and comprehensive statement of the law. Nothing beyond what we've always done. And again, when parties or anybody suggests to you, well, why do they need to do that? Why does that even need to be said? That's a great question. Why do we need to put that in the statutes? Well, because right now we're governed by what the Wyoming Supreme Court said in Solvay, and we're unfortunately limited when the parties come to us and they don't have, they haven't fully presented their case with all the law and everything that we need to consider. I don't know that I can say it any more clearly than that. If you have any questions, I'm happy to help you out with that.
Okay, thank you. Just going to start with Vice Chair, go to Representative Bear after that. Anybody on this end, questions? Okay, go ahead, Vice Chair.
Thank you, Mr. Chairman. I should have it's been a while, pulled up the Solvay case, but if you can just tell me, so what specifically did the Supreme Court say that was done that they said was not authorized? The remand for briefing, is that right?
Mr. Chairman, Madam Co-Chairman, I'm not sure if you're Co-Chairman, I don't want to get it right. Vice Chair, yes, it was a procedural issue, and the court said that we were not permitted to basically bring the parties back in to address a new issue that they, or an issue that they hadn't raised. Completely procedural. And the point that we tried to emphasize for everybody, and which I'm still trying to understand how it didn't get through, is this is a legal question. It's not like we introduced new facts, and it's not like we didn't allow the parties a full opportunity to address our concern. I mean, there was nothing in terms of opportunity that was taken away from the parties. And so it was basically this kicking it back to the parties to do additional briefing and to do an additional argument to resolve our question. And that's, the court said that when we sat in and this is really where I think the wheels come off the road here. The court said that when we sit in our regulatory function, because the statute already really says we can do this, but the court said, well, you can do that in your regulatory function. So remember, we have two hats. We sit as a court, where we are separate from the Department of Revenue, separate from the assessors, and we just decide who is right and wrong and create a record for courts to review. And then our other hat is our equalization function. This is where we are dealing with all of the assessors, and we are ensuring that property values are uniformly applied and that market value is applied. That's right out of the Constitution. So we have those two hats that we wear. And the court said, well, your ability to consider all the statutes and everything is limited to your regulatory function, which really makes no sense. We don't hold contested case hearings in our regulatory capacity. We are literally kind of the shepherd of the assessors in a sense. We are working with them, and then we are making sure that their valuations are statistically consistent with the law. And when we have to equalize, that's a terrible thing. That's a very intense, and we haven't had to for decades, but that's a completely different function than when we are sitting as a court, which is what happens with all these appeals that go up to the district court and then the Wyoming Supreme Court.
Representative Bear had the next question.
Thank you, Mr. Chairman. And thank you for being here, Mr. Hartzog. I appreciate your testimony, and I'm going to ask a question so we get that part covered, and then I would like to kind of make a statement about what I think may have created the issue last year, and then maybe that'll create an opportunity for you to share more information that can resolve some of those issues from last year. So my question is, in these cases, especially when you're dealing with the mineral industries, I assume that an attorney would be representing, the taxpayer. Just a question, is that the case? And then my statement is that the government it's a big thing to have to go up against. And when you guys put on your hat as a court, we in this country believe that courts are supposed to be blind, justice is supposed to be blind. I have to assume that the Supreme Court decision had some, in some measure, was looking at it from that perspective. So I guess the concern would have been that as the judge and jury in that court situation, if you're bringing in your knowledge of the complete statute that wasn't addressed by either party, then any advantage that might have been taken by either party could be lost in that situation. And although I may or may not have slept at a Holiday Inn last night, I'm not an attorney, so I guess, maybe the attorneys in the room would like to weigh in on this as well. But it seems like there should be some level of gamesmanship there for the parties, and especially when it's the taxpayer and the state fails to address something, it gives an advantage to the taxpayer. And I don't know, can you address that as well? Thank you.
Mr. Chairman, Representative Bear, your first question, attorney representing the taxpayer, I can't remember a mineral taxpayer, a producer that's not had an attorney. There's always so much money at issue. And the statutes are rather esoteric and fairly, they can be fairly challenging to work through. There is always an attorney with a mineral taxpayer, and of course the Department of Revenue, Department of Audit. Only the Department of Revenue, because only the Department of Revenue is there in an assessment capacity, but they have the Attorney General's office. So we are always dealing with taxpayers, with attorneys in mineral cases. Not always true of other types of cases, especially your local property tax cases. But getting to your second question, courts must be blind, and is there an advantage lost? I think that's probably not the right way to look at it, and I say that with an understanding that in a civil case, let's say, if you have poor counsel or you are pro se, there certainly is an advantage to the party who has better counsel. Certainly is that disparity can work in one party's favor. Certainly the case, but in every case, if the situation is usually that disparity or that difference works out in the quality of representation. The ability to present evidence or to make an eloquent argument to really, the charming. I used to work with Jack Spate. Jack Spate was a phenomenal, and is a phenomenal trial attorney, and he could wrap the jury around his finger. And he was such an effective attorney because he could do that. And he may have a losing case, but win the case literally through his trial lawyering. That's where the difference lies. But courts are never going to willingly be put into a place where they're limited to what part of the law they can consider. That has to be a constant. If you aren't starting with a comprehensive statement of the law, there's a good chance you're missing something. So I would agree with what you suggested in terms of the skill level of counsel or the quality of presentation. But in terms of what a court must be able to look at and consider, that you have to be able to look at the whole law. Otherwise, you're setting up the whole stare decisis and the idea that cases are precedent that can be relied upon time and time again. If those decisions aren't correctly answered because the law isn't fully discussed, boy, then you're creating a kind of a cascading problem with what the law is. And so that I would say is never the case. And as I mentioned earlier, even OAH, workers' comp, all of your different judicial type tribunals are going to need to look at the entire law so that the cases are correctly decided and that future bodies, future parties, the public can look at that case and believe that the case was correct.
Representative Locke has a question.
Thank you, Mr. Chairman. Just a question that hopefully I don't go beyond this bill too much, but does this limitation affect those same types of hearings at the local level in the counties? Does this restriction on that information affect them? Because I have actually heard that at the counties, that's an issue for them being able to raise issues that might come their way. So just curious if that's the case.
Mr. Chairman, Representative Locke, Yes and no. I would say that I actually sat down with all of the 23 assessors on a conference call, Zoom call, because they wanted to make sure what we were doing was consistent with what they understood our authority to be. And I think I quickly alleviated any concern. So what has to happen there, and this is just an understanding of what the board does, whenever we hear appeals from the local level, in every case, it's a record appeal. We are looking at what the county board decided, right? So that there was a trial below in front of the County Board of Equalization between the assessor and the taxpayer. It's always going to be a property tax issue of some kind. It can be an exemption at issue or a valuation question. And when we look at what the county board did, if we see something that they missed, that they didn't consider, we don't have the ability to just answer the question for them. We have to send it back to the county board, which can be tedious because then it can go back and forth if they don't get everything figured out, so that they can answer it in the first instance. And then it comes back to us, and then we decide whether they complied with the law in their administration of the tax statutes. I'll give you an example. We had a case recently where there was a series of appeals, and the taxpayer didn't appeal the last decision. And he figured that his earlier appeal captured the subsequent dispute that arose between he and the county assessor. And it never came up before the county board. Nobody before the county board ever presented the question of whether there was an appeal filed. They all assumed that there was an appeal filed. And then before us, the county assessor said, hold on here, the taxpayer never appealed that final decision by the assessor. So there was never an appeal filed. And it came before us, and we looked at that and we said, well, it does appear that there may not have been a timely appeal filed, but you need to tell us, county board, what you believe happened so that we can decide whether you got it right. We remanded it to the county board to make the decision. And we told them, look, if you don't have an appeal before you, if there was an appeal filed, then, as you know, the answer is you have to dismiss. It's jurisdictional. It's black and white. There's no question there. But if you do find that there was an appeal or an explanation for why there was an appeal, if the taxpayer was sick, if there was some procedural defect that interfered with the taxpayer's ability to appeal, then you need to make that decision so that we have a complete record with respect to that appeal. And that's what we did. We sent it back. And so to answer your question, whenever there is a problem at the local level, we can certainly identify it. And it does happen from time to time, but we don't have the authority to answer it in the first instance. We have to send it back because the county board is the only entity that has jurisdiction to hear that initial appeal, unless the exception being they can certify it to us, but we only allow that under our rules if both parties agree. And that happens every now and then. We'll have a conflict of interest with the county board, or we'll have an issue that's of such complexity and such gravity that the county board doesn't feel like it's in a position to do it. But we always make sure that both parties are assenting to that transfer to us for the initial decision. Hopefully that helps.
Thank you, Mr. Chairman, and thank you for that explanation. Now, one slight tweak on the question there, or kind of addition to the question. So this kind of puts the state equalization board in that position where there's a line you can't cross on bringing up an issue, for example, that was not presented by the parties. Do you believe that that restriction that was imposed at the state level might also be do the counties feel like they have a similar restriction? So for example, when the commissioners are hearing a case, do you believe they feel they're being impacted by that as well? So for example, if they understand the issue maybe broader than the parties bringing it, do you believe that they are also limited to bringing an issue up only bring that up because I have heard that, and I don't know if it's accurate or not. I'm just trying to understand your perspective of that. Thank you.
Mr. Chairman, Representative Locke, the county board is really, except for the fact that they have so many other jobs, I mean, you know, they run the county, and this is what we do 24/7. I mean, majority of our job is the adjudicative part. Maybe a third, 25% is the other side where we deal with the assessors at the end, and then we go into a whole process to look at all their values. But they are basically us, except at a local level. And so they can certainly raise issues if the parties come before them, and it does happen. If the parties come before them, the assessor and the taxpayer come before them, and let's say you have a real heady assessor or a county commissioner who has a feel, maybe he's an appraiser in his past life, maybe he's worked for a bank, and he looks at that and he goes, well, I see a problem here that you didn't discuss, Mr. Assessor, Mr. Taxpayer, and I'm bothered by it. I need you to help me with, help understand it, because I know that the law says this. That's fully within their authority as a court to get it right. If they have a question that the parties didn't address, every time they should, and they do oftentimes. And hopefully they have a good hearing officer that can really steer them and make sure that they're staying in their lane and not going too far off the beaten path, so that they get the right record in place and the decision written the right way. But the county commissioners are judges, just like the three of us as at the state board. There's usually 5, but sometimes 3 board members at the county level. And they absolutely have every bit of the authority that we do in terms of trying to get it right and to make sure the parties are addressing the law and everything that needs to be covered. Sure.
Thank you, Mr. Chairman. Excuse me. So it's sort of like Representative Bear's question from a couple times ago. But so when you're acting in this court capacity, and the idea of raising issues. So my question, like, to do an analogy or a comparison, if, let's say the Supreme Court in a criminal case is reviewing the record because an appeal was brought to them, but it's an evidentiary issue or something. So, and they're reviewing it and they think, wow, this defense attorney did a horrible job. Do you think that they then have the authority, or that this is something is done that they weren't asked to review that, but they say, well, we're gonna decide this was ineffective assistance? Do you think that that is something that is done or permissible by the Supreme Court?
Go ahead, Mr. Arts.
Mr. Chairman, Madam Vice Chairman, it's a criminal case, so it's quite a bit different. You have different constitutional mandates, and the gravity of it's a little different only because it's criminal. The Wyoming Supreme Court, and they can sua sponte, is what you're referring to, is raise an issue themselves. If they see something so deficient, and let's say the attorney for the defendant didn't raise it, which they almost always do, ineffective assistance of counsel is pretty much a built-in basis on which to appeal from a criminal conviction. But if they saw something so defective, the Wyoming Supreme Court, I believe, could and has, if it's that blatant and it has to hit what's called, so there are different standards of review at the judicial level. There's a clear error. If they see something so it just violates clear black letter law, there's a case on point, they see that the attorney or the judge below crossed the line on something, but the parties didn't raise it on appeal, I think they could. I don't do a lot of criminal law. It's been a while since I've done criminal cases, but at that court certainly can. I'm not sure that if we saw something that bad, yeah, we'd have to. And which is kind of what happened here. I mean, it wasn't a criminal case. The Solvay case was that. It literally, the arguments of the parties undercut completely the basic valuation methodology in the statute. Because the entire methodology for valuing soda ash years ago, the legislature sat down with all of the industry and everybody in the same room, and they said, we think a 76% deduction across the board covers it all. It's called the industry factor. And so in this case, and all the statutes lined up that way, they define all the definitions tied into that understanding. And so the case in Solvay was, not only do we get the industry factor, we're going to get an additional deduction for bagging expenses. And the Department of Revenue had went along with it. And when you looked at the statutes and understanding, when we did the decision, we went into a full discovery of what the intent was of the legislature. We went into the committee hearings. We went into all of the testimony. Everybody was singing Kumbaya on this thing, and the industry factor was fully understood. And so the notion that you get an additional deduction, and this was inferred from one provision of the statute, which tied back to a pre-codified version of the statutes. And so what we were able to do is look at that and say, look, there's a problem with how you are putting together or interpreting your valuation statute. What you're arguing about doesn't seem to lie. And so we, again, brought them in and said, explain to us, help us understand how you get this deduction, because it doesn't seem to reconcile with the statutes. And then we ruled on that, and that's where, of course, the Wyoming Supreme Court said we couldn't do that. But it's kind of an analogy to what you just said, where if you had a criminal case and the parties just completely missed it, and the Wyoming Supreme Court, could they identify an issue in a criminal case that the parties completely missed? I think so.
Excuse me. Well, so thank you for that, but I mean, it is an important analogy, if you will, because that, to me, goes to the heart of this, is that I don't think the Supreme Court does do that. This is what I guess I yet again need to do a little more research. I can think of one case where they decided there was structural error, which is that wasn't specifically, that wasn't raised by the parties. But generally, like the Supreme Court in their appellate function is not raising issues. And then that's the heart of what I'm really trying to understand here. Because if the idea that other appellate courts are not raising issues that are not brought before them, then it doesn't seem to me that in your court function, that it would be your job to be raising issues either. I mean, there has to be a point at which the appellate courts are dealing with the issues raised by the parties, it seems to me, because I feel like I was wishing Ms. Butler would have stuck around, but exactly. So that's what I need solidified in my mind, and I'll go do some better research on if that is something that, I certainly don't think it's regularly done. That at the appellate level, the appellate court is the one raising issues for the parties.
Mr. Chairman, if I may, Vice Chair Oakley, we had this discussion before, and you got to make sure you're clear on the level of review. If you are referring to a case that comes to us from a county board, we will see an issue, and it happens all the time, but again, we don't resolve it. That's not what I said. I mentioned before, we would send it back to the county board to address that issue. They may have missed it, which they did in the case that I explained with Representative Locke. The taxpayer in that instance didn't appeal, and nobody brought it up in front of the county board. And then they brought it for the first time in front of us. And we said, there certainly is an issue, but you didn't bring it in front of the county board. So now you have to go back to the county board and resolve that. That's the difference. If we're talking about a record review where we're looking at what a lower board did, we always send it back, always, so that they can resolve it in the first instance. because we're not the trial court in that scenario. However, when we're talking about state assessed, we're not talking about a county board. We're talking about, we're the trial court. We're hearing it for the first time. We are the judge and the jury, and it's always going to be the Department of Revenue and the taxpayer. So in a sense, we're not raising an issue that a lower court can raise, where we're talking about state assessed. We're simply making sure the parties are going to address all of the law. And that's what happened in Solvay. So make sure you're real clear on the difference between our role as a appellate body with the county boards, and when we're a trial court, we're conducting the hearing. We're the one taking the evidence. I oftentimes, because we lost our attorney, myself or Dave Delicath, he's an attorney as well, will sit as the hearing officer. And we'll conduct all of the pre-hearing processes. We go through all of that. It's a fairly painstaking process. And then we have a full-blown hearing with the reporter. We have opening statements, the whole thing, and all of the evidence is presented to us as the trial court. So you don't mix the two up. It's really a non-issue. And when you're talking about the Wyoming Supreme Court dealing with a criminal case on appeal, all I'm saying there is they can see an issue, and if they see there was a problem, what they would end up doing is sending it back to the trial court to resolve. They're not the trial court. There are a few, I hate to get off there, but there are a few instances by law where the Wyoming Supreme Court can sit as a trial court, but it almost never happens. They are, it's got to be one of these incredibly high-profile instances where the Wyoming Supreme Court actually has jurisdiction as a trial court, but they always sit as an appellate court and are always going to work through the lower tribunals.
Okay, is there anyone in the room who would like to provide any further testimony? Sure like to hear from you. Nobody on Zoom? Okay. Just stay right there, Mr. Hartzog, in case we, okay, any other questions? Because when we get to the floor, we want to be able to, because I think Vice Chair Oakley wants to manage this bill on the floor.
No, she does not.
I think we're working at it, so it's coming around. Okay, anybody else, any other questions? Is this the time right now? Okay. Okay, members, what's your pleasure on the bill?
Move the bill.
Okay, it's been moved by Representative Northrup, seconded by Representative Storr. Okay, let's flip through the bill over to page 2 and 3. You can see the new language to existing statute on page 3 to deal with the Solvay case. Is there any comments or thoughts about that?
I have one quick one.
Okay, Representative Zwanser.
Thank you, Mr. Chairman. I'm just making sure on the effective date. I don't know when the usual appeals and the cases come to you, but do you expect any before July 1st this year that you would need this? Actually, is there anything since the Solvay case you've actually likely needed this and you wish you had that, or is it kind of a one-time thing? And that's my question, I guess.
Yeah, Mr.
Is on the
Hartzog.
effective date.
Mr. Chairman, Representative Zwanesser, I'm ambivalent. It's really, like I said, it's happened 5 or 6 times. Right now, we're actually, and this is kind of funny, we dropped a footnote in a sales tax case between a sales taxpayer and the Department of Revenue, and we dropped that footnote and we said, look, you are missing a key issue, but you didn't raise it, so we can't raise it, but we're pointing it out. As you might know, state assess comes back every year because almost mineral taxpayers, they keep producing minerals. And so if we have an issue in one year, we're going to have the next year, it's going to come up in the audit, it's going to keep coming up over and over and over. Same is true in a sales tax case. In this case, and this kind of goes to the question of that Representative Locke asked, or Representative Bear, about, the gamesmanship. The Department of Revenue, I believe, saw what we saw, and then the very next cycle agreed with us. So now we have the first decision, which we had to address incorrectly, by our view anyway, because the parties didn't raise a key component of the statute, and we thought got it wrong. We dropped that footnote, it comes back the year round, the Department of Revenue agrees with us. Now we've got a hearing coming up this spring to address the footnote that we dropped, the interpretation that we thought was correct. But the unfortunate part of that is we had to address the first time wrong. We had to go ahead and say, yes, taxpayer, yes, Department of Revenue, you're correct, even though you're wrong. But because we weren't able to bring up the issue, we were locked into what the parties basically presented. But now we're having another hearing to go through all of it again in the next cycle. And we're gonna get the answer, we're gonna have the ability to answer it correctly this time, only because the department agreed with us. Does that make sense?
Yeah.
Anyway, so no, I don't think so. We don't have any cases right now that are just wrong.
Okay.
But it can happen, but I don't think that moving the date of the enactment date up is necessary. I think it's fine.
Okay, any other questions? Okay, back on this bill now. Any other suggestions for amendments, members?
Question.
Okay, question being called on the bill. Ms. Jeffrey, please call roll on Senate File 55. There are no amendments.
Representative Bear,
Aye.
Representative Byron,
Aye.
Representative Locke,
Aye.
Representative Northrup,
Aye.
Representative Oakley,
Aye.
Representative Storer,
Aye.
Representative Struck,
Aye.
Representative Zwanitzer,
Aye.
Chairman Harshman.
Aye.
The bill is a do pass with 9 ayes.
Very good. Okay, well, we'll have further discussion on the floor manager of this bill. And that concludes the work today of our meeting. So thank you, Mr. Hartzog. Thanks, everyone, for joining. Thanks for your good work. And we'll see what other bills come our way for future meetings.
Thank you so much, everybody. I appreciate your time.
Yep, thank you. Okay, members. Have a wonderful day. We're adjourned.